Thank you, Lindsay. Good afternoon, Hawaii, although I think it may be the tail end of morning for you in where you are. I'm in Oregon. My name's Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals, which is Oregon's intermediate appellate court.
Good morning, or actually good afternoon. My name is Doreen Hartwell, and I'm an attorney in Las Vegas, Nevada.
Good late afternoon to you from Florida. My name is Steve Jewett. I'm a county court judge in Orange County in the 9th Judicial Circuit of Florida. That's Orlando. It's late afternoon for us. It's almost evening.
Students, please introduce yourselves.
Hello, my name is Frances Balsita. I'm a junior at McKinley High School, and we're accompanied with our teacher, Sean Kamita.
Hi, my name is Byron Kim, and I'm a senior at McKinley High School.
And I'm Erwin, and I'm a junior at McKinley High School.
Thank you. Well, as you know, today is question 2, which starts with this quote from Thomas Jefferson. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? And finally, what are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Thomas Jefferson wrote this quote in a series of letters between himself and James Madison. In simpler terms, Jefferson claimed that all citizens are guaranteed the Bill of Rights and no government may infringe upon them. This quote is Jefferson expressing his want for a Bill of Rights to accompany the Constitution. He believed this was necessary to secure personal liberties to citizens, as the central government may grow too strong and restrict citizens' rights. Consequently, in its preamble, it is stated that our liberty and justice are secured through the Constitution. Before we express our stance, we would first like to explain what agreeing and disagreeing with this quote means. To agree is to believe that rights in the Bill of Rights are natural. To disagree is to believe that the rights are conventional. That being said, Byron and I agree with Thomas Jefferson. In our opinion, the rights included in the Bill of Rights are natural, meaning American citizens are guaranteed the full Bill of Rights for the moment they were born, and even before that, and no government may legitimately infringe upon them. We believe the sole purpose of the Bill of Rights was to put pre-existing, pre-political rights into physical form. Moreover, the government may not infringe on any American citizen's rights. If they were to, it would be wrong. If the Bill of Rights were repealed, Jefferson would argue the rights would still exist because natural rights exist whether or not they appear in physical contract.
I, however, disagree with Thomas Jefferson and believe that the Bill of Rights is conventional, meaning it exists because people agreed it should. My belief also means that the amendments from the Bill of Rights can be erased if a majority decides it should be repealed. The Bill of Rights is simply a coined name for the first 10 amendments, and therefore, just like Amendments 11 through 27, the Bill of Rights can also be repealed. As a collective, we believe that National Bill of Rights and state constitutions complement each other and that both are necessary. Through the Supremacy Clause of Article 6, Clause 2, the Constitution, federal laws, and treaties under their authority take precedence over state laws. The National Bill of Rights serves as a base for state constitutions and subsequently promotes uniformity. Using the Bill of Rights, states are then able to broaden or specify the Bill of Rights through their constitutions as they deem fit. For example, in State v. Kino, Hawaii Supreme Court specified the Fourth Amendment by concluding police officers should not use their intense authority to subject people to unreasonable searches. The 10th Amendment, which states the government is limited to the powers listed in the Constitution and that all other powers are for the states and people, was created to ease the fear that the federal government would dominate using their power and allow leeway for states to specify the Bill of Rights.
The Bill of Rights has both positive and negative rights. Positive rights are rights that guarantee one's freedom to do something. For example, the right to education guarantees one's right to receive an education. Negative rights are rights that protect you from something. For example, the Fifth Amendment protects you from self-incrimination. Both types of rights are essential to keep the order of our nation and to ensure liberty to the highest standard. Therefore, we do not believe it's possible to idolize or praise one type of right over the other. Both rights are equally vital to our society. Without positive rights, we would not have no freedom to express themselves, gain an education, or live a peaceful life. Without negative rights, people people could be subjected to severe and unfair punishment. Both types of rights are necessary to keep the harmony of our laws and to prevent the imbalance of justice powers. This concludes our presentation.
Thank you. For your first follow-up, what limits, if any, should be placed on the rights listed in the Bill of Rights?
I'm sorry, I lagged on this side. Can you repeat that question?
Sure. What limits, if any, should be placed on the rights contained in the Bill of Rights? And who should do the deciding about those limits?
Well,
No, go ahead, Erwin, sorry.
well, for the Bill of Rights, it's important to make sure that there's an equal balance between the government and how far they can control its citizens, and then how much rights these citizens have themselves. And in order to determine that, that should be left up for the judicial or those types of people who can interpret the law in a way where it's relevant to our generation today.
Expanding on what Erwin's saying, I agree that there, just like how religious freedom is often a topic brought up to the court through cases like Employment Division v. Smith, Wisconsin v. Yoder, which are cases that we covered in question 1 of this unit, so it's relative.
And adding on to what Francis said, those cases where it's more based on the religious side of things, the Bill of Rights should be a little bit more flexible to adapt to how modern society is and how it should be treated.
Muted. You're muted, Doreen.
Sorry about that. What is the difference, if any, between rights added through the amendment process and those established by a court decision?
Usually whenever a type of right is established within a court, that would be relevant to a particular type of group. And then if it's something that's going through the process of the amendments, that would be more so related to everyone in a sense.
To elaborate what Erwin is saying, rights established in the court are usually things that are interpreted, and it's very based upon the case presented to the court. And it's something that's interpreted to be applicable and may be applicable to other circumstances, whereas what Erwin is trying to say is amendments are general and they're set into the Constitution as more of a reference, what people can cite to.
No, I want to mute. Okay. In your opening statement, you talked about, and you actually you took sort of two sides to that as dealing with the Bill of Rights. One, the sort of natural law philosophical, and then the other one with that it's really because the people agree. But talking about the Bill of Rights, how fluid are they, or how fluid should they be? Are you of the opinion that, well, the framers wrote it this way, and this is, if it's not in there, it shouldn't be considered? And what I'm really kind of talking about is, like, in the Second Amendment, it talks about the right to bear arms. Do they talk about the right to have a bazooka? Or, is it fluid enough to include that, or should that not be there?
I think it really comes down to context. And in the Constitution, it's a living document. It's supposed to be constantly adapting to modern day society. At the time, the right to bear arms was important to the people because there was no established standing army. It was about the people defending themselves, militias defending their people. So that's why the right to bear arms was so important. Back then, they didn't have the type of weaponry that we have today. They didn't have like these crazy tanked built machines that we have access to. And that's why I believe that the Constitution and rights should always be sure that they are applicable to today's law and take into consideration how things have changed since its establishment.
Adding on to what Francis said, it's definitely something that should be adaptable in a sense as to modern day society. Back then, when the founding fathers were creating the Second Amendment and the Bill of Rights, their interpretation of a gun would be a simple rifle or a small pistol. They never expected the guns to expand and adapt. And with that, the gun laws have changed as well. Now there's gun restrictions, so that way now not everyone can get a gun. So definitely the Bill of Rights has adapted and should be adapting into modern day society.
Moving to your state constitution, if you were, say, constitutional lawyers arguing cases to the Hawaii Supreme Court, are there any instances where there's a rule of law announced by the United States Supreme Court about a right in the Federal Bill of Rights, where if you're taking the case to the Hawaii Supreme Court, you would argue for a different rule in front of the Hawaii Supreme Court, and what would be different about it?
May I ask you to rephrase that? I got a little bit lost in the sentence.
Sure. If you want to argue, let's say you're going to argue a case under your Hawaii Constitution to the Hawaii Supreme Court, and you're now constitutional law experts, you know a lot of federal constitutional law. Are there any instances where you would argue to your Hawaii Supreme Court it should decide things differently from the United States Supreme Court?
Well, definitely there are some types of rights that, again, the National Bill of Rights set the foundation for, and it's our state to be able to expand in a sense. And if there is a different approach that, let's say, for example, a different state is able to handle it, it can definitely be taken into the court as consideration to be like, hey, look, there's this different type of thing that we could be doing, and this is how it could be beneficial for us. And we can bring up how, like, oh, we can see how this is affecting them in a good way and show them like this is effective.
I agree with Erwin. If we see another state doing something that we would want and we think would work well for us, personally, I think that dealing with culture is top priority to preserve in Hawaii. So if there's things, education laws in the states don't have the same, in state constitutions of mainland states, they don't have the same specifics to preserve culture as Hawaiian culture does towards our education. So in our state constitutions, we make it mandatory that students learn about Hawaiian culture, and things like that I think would be more of priority to our state, and they might want to expand more upon it. Things like Hawaiian cultural gathering and territory are also things that may be brought up or expanded upon.
That's it? All right. I want to hear more about that. Serious. I'm not done. I would love to hear more. Good job, you guys. I thought that your opening statement was interesting in that you really went on a philosophical trip with us. You know, am I muted? No. Okay. More so than I've seen in others. So I enjoyed that. I think that's really because you have to recognize, and you guys do, that our whole construct, you know, the whole constitutional construct and all that is based upon, you know, the bedrock is all of that, the natural law stuff. So I like that. And I did really like how it was two guys, you guys have your opinion and Frances has her opinion, and she's gonna put it out there. I did enjoy that. I really want to hear, I'm sort of like the question I asked about, and I didn't really get into it too much, but state constitutions, national constitutions, the conflict between the two and where they can be problematic. And I'm really interested in what you were talking about at the very end. I thought that was really interesting. I'm glad you put that in there. I'm going to follow up myself and look into that a little bit. I was aware of the fact that in Hawaii, that was, that culture is a very important thing, but I didn't understand that it was in your constitution. So I really enjoyed it. Thank you very much. Time went by quick. That's a good sign.
Same here. That was your prepared remarks. You took very clear stances, and I actually appreciated that the team had competing stances. I think most of these questions, I sometimes get alarmed if everybody sees things the same way, because these are very hard questions with a lot of gray areas, and to witness a reasoned, principled stance with very civil disagreement is great. And I too enjoyed your discussion of your state constitution. I appreciated the specific references to the Hawaii Supreme Court case in your prepared remarks. I kind of wanted to know more about how Hawaii has protected criminal procedure rights differently from the national government. But then I really enjoyed too what Steve was referring to, your discussion at the end about the unique cultural protection components of the Hawaii Constitution. And I'm just very impressed about your knowledge of not only the national constitution, but of your local constitution. Thanks.
I thought you guys did a good job. And not to repeat, and I totally agree with my co-judges. Your prepared remarks were interesting, and I thought that I too appreciated that you looked at it and viewed it from more of a philosophical perspective with regards to natural rights versus in the government's in the stance that the government should never infringe on those natural rights, and that they exist regardless of whether or not they're in the Bill of Rights. And I appreciated that Francis had a different opinion on that and viewpoint. I thought that you guys set forth you answered the question. You went into the positive rights and negative rights. You identified some of each, and you were really clear, and you understood the fact that the negative rights are really meant to protect citizens against basically the government and overreaching by the government. I appreciate too your responses to the questions, and to the extent that you didn't understand or needed clarification, that was good to request that. Again, you answered the questions asked, and it was really a pleasure hearing your thoughts and the support you had for your opinions. And so well done, and good luck as you continue.